is doing it.
And I hope I didn't just unmute or mute everybody as I was trying to mute Kathy. It said mute all. So Board Member Hayes, could you try to unmute and just see if you, oh, you can. Okay, good.
Yes, look at that. Work.
Okay, great. And then
We got that bad echo though. Somebody. Yeah, that's bad. Is that a new ring
coming from
for someone?
Kathy, and it's not letting me mute you. So Kathy, you might need to kick, I don't know, go out and come back in.
It won't let me out. I'm trying.
Angie, can you kick her out?
All I can do is change her role. It says that I muted her. Oh, maybe somebody else took care of it because now she's gone. We just got one. Good. There we go. I think the problem solved.
Okay, so everybody's here, we think. All attendees are muted, and we cannot unmute. Oh, I'm not sure what that
yes.
means.
Yes, we can.
Yeah, everybody should be able to unmute themselves. And it does sound like Board Member Thorpe is likely not going to attend today. So.
Oh. All right, then I think we'll get started. Is everything running Jerry and or Angie, do you think?
Yeah, I think so. Jerry, are we good on streaming? Can we start? Alex or Jerry, can we go ahead and start? Is the streaming ready? He cannot unmute. I see. But yes, go ahead and start.
Yeah,
sorry, Jerry.
Thank you. Lorianne is trying to log in now. Says,
great.
Says Dr. Voorhees. Let's just wait one more minute and see if she can.
Sounds good. Michelle Buse, you'll want to mute.
Let's see.
For all those who are attendees, if you do want to speak, please raise your hand because apparently you can't unmute yourself, and I will unmute you, or you can also include in the chat that you're wanting to speak.
Lorianne, are you there yet?
All right. Thanks for turning on your camera, Carol.
Oh.
It just feels so weird to look at a blank screen.
It was a little disembodied, wasn't it? Sorry.
Yep.
Now you'll have to look at me. I'm not sure which is worse.
Oh, it's better than not. Thank you.
Sure. That's something of a compliment.
Well, just wait. Ben will say kick you out too if you're not nice to him.
Yeah.
So Ben's kicking everybody out.
I was still waiting for Lorianne for a minute. Do we know? There's another chat. Let's see.
It looks like Leah's asking.
Oh, I don't want to make us late though for the next group. That's the only thing that I'm
Do you want, I can call board member Thorpe and just see if she's needing help getting in. Oh, look, there she is. See, I just said her name and then she appeared. There we go.
Yeah. That happens. Okay, then let's get started. Welcome all to the Early Morning Law and Licensing Committee for September of the Utah State Board of Education for September 2020, September 4th. So my name is Carol Lear and I'm the chair of the committee. And I would just like to have, if they would, this will allow us to both check mics and to see who is in attendance. I would just like the board members to introduce themselves, maybe starting with Mike Haynes.
I'm going to turn on my camera too and say hi. Good morning, everybody. It's Mike. I'm Mike Haynes from District 11.
Thank you. And Brittany?
Good morning, Brittany Cummins from District 6.
Thank you. Laurie Ann?
Laurie Ann Thorpe from District 3.
Welcome. And Cindy?
Hello, everybody. Cindy Davis,
Thank you.
District 9. But here to enjoy the conversation from all parts of the state.
Thank you. And thank you to our staff who made this happen so seemingly smoothly early in the morning. So the first item on the agenda is, get my right paper here, is item 1.1, which is an action item, licensing assessment selection and passing standards process. And the specialist identified for this is Jennifer Thronson. So Dr. Thronson, if you're on, would you please go ahead and explain to us what we have in front of us?
Yes, thank you. And I don't see a place to turn on my camera, so I apologize for just being a talking head this morning. If I figure that out, I will, let me just check my name real fast, see if I can fix that, because there it is. Oh, it moved me. 1 second.
I just moved you to panelist so you can turn your video on. So you should be able to now.
Okay, and I'm just going to do my hand because that seems to make it so I'm not an unsolved mysteries candidate. Good morning, Dr. Thronson, Director of Teaching and Learning. Excited to be with you today, and this is in connection to Board Rule R277301-9. So previously, I brought you the process for how we go about developing competency-based endorsements. Also part of 301-9 is a need to develop a process approved by the board to review, adopt, and establish passing standards for all assessments related to educator licensing. So those are things related to like getting your elementary license, your secondary license, or earning a content area endorsement. So this is the process taken through our staff across the agency to think about if they want to test for their license area, or if we need a test for a particular endorsement. What is the process to go through reviewing those assessments that are available, selecting an assessment, and setting cut scores or passing standards related to those adopted assessments. So this is kind of your process for that. The top section, the first 7 steps, is reviewing and adopting assessments. So the process that staff would go through if they were to adopt an assessment. And the second part is how they would go about establishing a passing standard for the selected assessment. This was also reviewed with Zach Christensen from a purchasing standpoint. Although when we select an assessment, we're not paying anything, but there is some kind of procurement thoughts because our educators would be paying the fees to these companies. So we wanted to make sure that we have some support of the procurement process embedded within this without it going through like a formal RFP process, but something that would still be legally defensible around how we would go about assessment selection as well as the process for setting standards. So open the floor to questions as needed.
Board members, committee members, do you have any questions for Cindy. Cindy, I thought your hand was raised.
Yes, it is. Sorry. It just takes a second for my mic to connect over.
Sure.
Hey, thank you, Chair Lear, and thanks, Dr. Thronson. Could you help us to know, I'm assuming since the endorsements are pretty content specific, that something like the praxis would be one of the things that would be considered. I guess I'm wondering if the praxis is something that would be considered, and then also, I guess, just want to add a little bit of thought about that. I have some concerns about that because it actually, I'm hearing, is less expensive for these folks to take the whole praxis with all these different sections rather than to take them piecemeal. And I'm wondering if that's different for our secondary folks who would be seeking specific endorsements. If you don't know the answer to that question, then I'm just asking that as this group move forward, if we move forward with this process, really look carefully at that. The other thing I'm a little bit concerned about is that we went to a conference in DC, and a woman had done a lot of research on the praxis and had compared other licensing types of competency tests, and the passing rate for all of these other professions were like in the 80%. And she said the passing rates in these education praxis exams are in the 40%. And she said it's not because if you look at other factors that these people are less intelligent than the other people. She said there are some problems. So I came home and just asked a couple of students, right, the very first two students I saw, how was your experience with the praxis? And one said she passed all the sections, but one section she didn't pass, and she had to take it 3 more times. And it was actually less expensive to take all 5 sections than to just take one single section. And then the next student I talked to said he had to take it 5 times and had passed 4 sections, but because of one section and even down to like one question, he didn't pass it. And he said there was a question like, how does the migratory patterns of families in China compare with the migratory patterns of families in South Korea? There's some kind of random questions for this elementary school teacher. So I'm just laying it all out on the line. I have some serious concerns about the cost and the time and some of these problematic issues with the praxis. So do you know any information there already? Is that something that certainly would be considered in this? And if not, would the group be willing to really dig in there?
So, Chair Lear, may I respond?
Please do.
Thank you. Board Member Davis, yes, cost is number 4 on this process on review and adopt. So praxis would be one in the collection. So the intent would be to kind of survey the field, see what's available, bring all those in, and then look at the specific metrics, the blueprint of those, how well they align with our standards, all of those pieces first. And then cost is definitely part of the equation. So right now we have that elementary praxis that has reading, writing, math, science. And so there are multiple sections that they have to go through, and if they don't pass the math, then they take it multiple times. What we see from traditional practice is the reason people aren't passing the first time through is sometimes they're taking it too early in their programs. So they haven't gone through enough of the teacher preparation program to really have the knowledge and skills to pass those assessments. Other times, like you said, they're having to take it multiple times. They might have a particular deficit, or maybe they don't know how to interpret graphs, such as the question that you are talking about with migration patterns. It was probably some visual display of data. And so there's certain skill sets that they need, but cost is definitely going to be part of the factor. Our intention is not to create such a barrier to earning your license that cost becomes a prohibitive piece. So as we would look at that, saying, okay, if somebody needed to retake an assessment, how much does it cost? And what's the burden on their time and investment in retaking that? And so this process actually starts to broaden into that more full picture than what we had before. Before we were like, praxis is it. That's our opportunity. We kind of have no other option to say differently. It was like praxis or nothing. At this point, given the flexibility that the board has afforded in the rule, No longer are we kind of constrained to particular requirements for those assessments, which is what this process is trying to define, or what are those requirements. So if we go through the process with some of these assessments, and we, you know, as a board, do start hearing feedback around this, that would be a time for us to refine the process. But ultimately, this does allow us to kind of open up to the field of assessments, to really look at what's available, best aligns with our, you know, our needs in Utah, as well as to consider the cost pieces, as well as availability. Knowing our teachers are all over the state, thinking about the geographic availability of those assessments. How far do they have to go to find a testing center? Is it available at home? You know, with digital proctoring becoming more and more available because of COVID-19, those types of pieces. So the opportunity that we are afforded, given the rule revisions, actually does allow us to have greater flexibility and broaden our opportunity of which assessments we have allow for, which also would allow us to have multiple assessments that people could pick from. So there's nothing that prevents us from saying Praxis is the only one. We might say Praxis and another, you know, assessment, and the teachers can choose which one best meets their needs, their availability, those kinds of things. So this really does give us greater span of being able to be receptive to our educators trying to become licensed or endorsed. From an elementary standpoint to a secondary, it is different. Secondary in general is taking that content test, and there's one test, there's one, you know, if they have to retake it, they have to retake the whole thing. But again, that's generally after they've earned their bachelor's or had significant coursework in that area. And so there is some differences between our elementary and secondary folks. So I'm going to leave it at that, and feel free to have follow-up questions, of course.
And I see that Dr. Dixon has joined us and has her hand raised. So do you have something to add?
Oh, thanks, Chair Lear. No, actually, Jennifer addressed the things I was going to mention. We do have those pass rates that Dr. Thronson can bring if either for Board Member Davis or if you wanted to look at those at a different time. We track the pass rates over time.
And Board Member Davis, did that answer your question, or do you have others?
Yeah, just a quick follow-up. Thank you for that. I would just ask that the pass rates be included in the step where we're looking at the costs, because to look at a singular cost and compare it across assessments is not the full picture. If that presenter was right and there really is a 40% pass rate across the country on Praxis, that actually increases the cost if you have to take it 5 times to pass it. And I just think it's a shame. I know a woman who went through her whole college degree, got a degree in music education, and for whatever reason took the Praxis a few times and couldn't pass it. And so now is not teaching after receiving that bachelor's degree. I think it's unfortunate. And the other unfortunate piece is that when we look at data for underrepresented populations, we are finding that that some applicants will take the Praxis multiple times and then they'll pass it. And the data that was presented was that underrepresented populations will take it once and then they're not taking it multiple times, whether it's due to the cost or whatever those factors are. And so then as we make a goal to increase representation in our teaching force, I would hesitate to put too many assessment gatekeepers in and actually go backwards on that goal as well. So if those things could be considered, then I'm comfortable moving forward with this rule.
Yeah, and just to add on to that, the passing standard part comes, we would select the assessment, but to be able to figure out what the passing standard is isn't set by the testing company. They have a recommendation, but ultimately Utah determines what our passing standard is. And so below is that process in the kind of 2-tiered system here is establishing the passing standard. Part of the process is to look at, you know, what does the provider recommend? What do we see locally if we've already been giving this assessment or if other IHEs have been using this as part of their process? What have other states done? So we've done this similarly with like PPAT and a TPA, is kind of looking at these multiple data sources to inform. So for example, with the PPAT, which is our pedagogical performance assessment for teachers, that one, the recommendation by the provider is 42. As a state, we looked at what other states have selected. No one has selected 42. We looked at our own testing data because UVU and WGU had some testing data in their banks. And using those data to inform the process, we went with, I think, a 37 for elementary because we have seen what other states have done. We have looked at our own data, and knowing we're new, we went with not what the publisher of the test would suggest as the cut score, nor has any other state. And so this process seems to work to really take into account our teachers and our educators and where we are. But it also gives an opportunity for us to look at the data after a certain amount of time or a certain number of test takers to say, how are they performing? Do we need to adjust our cut score up or down? Currently, for example, our elementary praxis has an 85% pass rate on the first attempt. That's actually a pretty good pass rate. I'm not saying there's not these outliers that you've experienced as well, Board Member Davis, that aren't passing. But in general, 85%, if we were in a school system saying 85% of my kids are passing, we'd be pretty satisfied. I'd still be worried about the 15% and thinking about what we need to do differently. But 85% is not a huge flag for concern. And so that's kind of what this process affords, is an opportunity to look at the testing data to see if we need to adjust our cut scores based on the data that we actually collect. So hopefully that gives you some level of confidence or quells any concerns, as we do have a mechanism in process to really address those concerns that may come up as we go.
Thank
That's really great. Thank you. That helps a lot. And if we can kind of disaggregate some of those even percent who's passing and who's not and why, and are there other, factors involved there? And then just that it's better than the national data. So that's helpful. Thank you.
Thank you. I have 3 just literally yes, no, or single answer questions, if I could ask those, because I don't see any other hands. So I think these are to Jennifer Thronson, if that's okay. So one of my questions is, how much does for instance, the elementary praxis cost? And in just once to take?
I believe it's between 140 and 150, and someone will text me if I'm wrong.
And then how, isn't there a provision in the rules or the process, and maybe this is something that's forthcoming, for a student to pass the praxis for some, aside from someone who would have a 504 accommodation, but is some process for an appeal if a student can't pass the praxis, or is that in contemplation?
I don't believe we have anything in place. We could definitely look into it and see. Malia might speak more. I don't know if she's on the call.
That's okay. I just, if you don't think there is one, I just hope that would maybe be a consideration if there really are some strange outliers, and it would keep people, especially minority students or sort of the less typical graduate from passing. I would hope there was some appeal option or a alternative assessment. And then my third question is, the praxis or whatever is being developed, is this going to be only for students in traditional preparation programs, or would this be required of the alternatively prepared?
It is required for any licensing educator. So both sides of that equation.
Okay, thank you. That's super helpful. I'm ready for a motion if there's a motion from a committee member. Looking. Board Member Cummins, Vice Chair Cummins.
I move that we approve the proposed process and forward to the board for their consideration. So the assessment, selection, and passing standards process, excuse me.
Thank you. Any discussion to that motion? Do you need to, do you want to comment on your motion, Vice Chair Cummins?
No.
The motion is that the committee approve this licensing, assessment, selection, and passing standards process and forward it to the board for final reading. Any other discussion? With that, I'll vote. We'll take a vote. And again, this is just easier for me to, if I can just call your names quickly. Committee Member Haynes,
Aye.
Member Thorpe,
Aye.
Member Davis,
I
Member Cummins,
Aye.
and I vote aye. So it's unanimous. Thank you very much, Dr. Thronson. And I'm just checking a chat item. Oh, thank you. We were just informed that there isn't an alternative or an appeal process to the licensing, to the Praxis situation. And I'm sure that'll have further discussion. The second item on the agenda is item 1.2, which is also an action item on R277-102, which is a proposed new rule on adjudicative proceedings. And we have some public comment on this from two individuals. One was just a written public comment that I emailed you this morning from an attorney, David Mortensen, who has participated in one of these processes with the board. And a second comment is from Tracy Watson, who's general counsel for UEA, the Utah Education Association. So I think it might be most helpful if we hear an explanation of R277-102, and then we'll go to Ms. Watson to make any comments she has. So with that, I'm assuming the person that would talk about this is either Ben Rasmussen or Michelle Buse.
Thank you, Chair. Ben Rasmussen, Director of Law and Professional Practices. R277-102, we had basically a related rule that sunsetted about 6 months ago. Came up for continuation, and the board decided to repeal it. But after giving that a little thought, the AAGs have recommended that we readopt the rule and put a new rule in place. What R277-102 is meant to do is to provide guidelines for conducting proceedings, and specifically in relation to the Administrative Procedures Act. The big thing that the rule does, if you'll see in Section 3, is it initially designates all proceedings, review proceedings before the board as informal hearings, and then there's a procedure that they can be converted to formal proceedings. This is something that Mr. Mortensen mentioned in his comment, that those were undefined terms, but those are terms under the Administrative Procedures Act, and this rule incorporates that, and that by using those terms, that incorporates a lot of procedures that come under the Administrative Procedures Act. But R277-102, we kind of took the old language that had been in place. The original draft kind of updated that, and then we've gotten some feedback from Chair Lear and from Assistant Attorney General Buse that we've updated that. Draft 3 is the current draft. Draft 3 was posted this morning, and it includes a little bit of language that Chair Lear had suggested on line 13 and 14 there that just kind of updates the applicability of the rule. But if there are questions about the rule, myself and Michelle Buse are happy to help you out.
So Michelle, do you have anything to add? And then I'll go to the public comment. AAG Buse, are you on?
I'm so sorry. I do. I was trying to unmute myself. I apologize. I just wanted to add in response to Mr. Mortensen's comment that I feel it's very appropriate not to put a detailed procedures in place, because what qualifies as due process varies so much depending on what the rights are at issue. And that's why we trust hearing officers to research those issues and make sure that, depending on whether the individual has an attorney present or not, that hearing officer can accommodate and make those processes be appropriate for the parties that are there and for the rights that are at hand. A hearing officer doesn't want to be overturned by a court, and they always know that individual has the right to go to court. And so they want to make sure that the processes are legal and that they are responsible to make sure that the individual's due process's rights are protected And so we do rely on the hearing officer to appropriately determine what level of due process needs to be afforded the petitioner at any individual hearing. And so I think it is appropriate to leave it open and to be able to rely on what is spelled out in the Administrative Procedures Act and the discretion of the hearing officer that the board chooses and the panel that members of the board that are selected to do the research and to protect whatever interest is at hand. So that's my comment.
Thank you. Thank you so much. With that, I'd like to hear from Ms. Watson, and I apologize. This has been a little bit of a moving target. So you probably can tell us if you're speaking to draft 1 or 2, probably not draft 3, but we would appreciate your comments. And so whoever has to unmute Tracy Watson, General Counsel for UEA, please do so.
I've unmuted her.
Thanks.
Can you hear me?
Yes, we can.
Awesome. Thanks for letting me participate. I just,
And Tracy, will you introduce yourself just for the recording?
Sure. My name is Tracy Watson. I'm the General Counsel for the Utah Education Association. Carol, you know me quite well because, no, I did not see draft 3.
I'm sorry.
I am not the early bird that some of you are. So I'm working off of draft 2, but my guess is my questions really sort of are more general in nature. You know, I think having a rule like this is really important and necessary because there are procedures that do sort of implicate the board to have a hearing. And we've been talking about this for a few years, and different boards want different participation levels, but I do think we need a rule in place and a process in place for the board to hold a hearing. So overall, I'm in support of this type of rule. Michelle Buse's comments were really helpful for me this morning, and they've helped sort of answer a few of my questions. But specifically, working off of draft 2, you have a definition of default beginning on line 19. And I'm just wondering if that definition is the same as that in the UAPA, and you refer to that in line 66, where you start with the R277-102-6 default. So I don't know. I mean, it sort of would indicate that maybe there's a different definition of default, and just something for you to look at. Again, same section, 102-2, subparagraph 3, talks about the presiding officer, and in Michelle Buse's comments, I mean, we're all seeing this really as a hearing officer, even though it's a presiding officer. And so, you know, different agencies do different things, but I wonder if you want to flesh out more specificity regarding the credentials for the hearing officer. Because it really is going to be a hearing officer, whether it's an informal hearing or a formal hearing. So do you want to consider having some specificity? And the same is true for the hearing panel. In section 102-4, draft 2, beginning on line 38, the agency head may designate a hearing panel. In Michelle's comments, she seemed to indicate that hearing panel might be members of the board, which would make sense, but it's not really specific in the rule as proposed whether or not that hearing panel would be members of the board or not. And then just a comment, you know, there seems to be a default that the hearings will be informal unless designated as formal. And I certainly agree with Michelle Buse again that due process requires a lot of flexibility. The only thing I bring to your attention is if when hearings are informal under UAPA, it's assumed that the appeal process would be to a district court and probably de novo, and that can be very expensive for the agency and for the opposing party. And then in section 102-7, recommendation to the board, draft 2, beginning line 79, it talks about the board may approve alternative findings if the board disagrees with the proposed outcome in the hearing report. That, I think, is problematic. I think we've seen that as problematic before. I think you got to consider whether or not you want to give the hearing officer or the presiding officer more discretion, or at least specify that the board to disagree is limited to the hearing report and the evidence presented at the hearing. The last comment I want to make is really for this committee to make a recommendation on this kind of rule to the board as a whole. I kind of wonder if you don't need a little primer on the UAPA and how the Utah Administrative Procedures Act works, because there's a lot of references to UAPA, and in trying to understand the rule, I had to go back and forth. And I just think it's really important that you understand, as you undertake to hold hearings or to designate people to hold hearings for you, how you're actually going to do that work. That's all the comments I have. Thank you.
Thank you very much, Tracy. Michelle, would you like to respond to any of those AAG views? Would you like to respond to any of those concerns briefly?
That was a lot of information, Tracy, and a lot of good points. And I didn't take notes well enough to recommend amendments all at one time. Perhaps it's something that we could table and work closely with Tracy or Ms. Watson to find some middle ground and propose some amendments that might be amenable to UEA as well as the board or this committee for next meeting. I don't know that there are any hearings that are pending or in the wings that this would be applicable to at the moment. And so I think that you as a committee have the time that you could delay this to next meeting and allow us some time to get together and work together to find some amendments or proposed amendments that would be acceptable.
Thank you. I think that's a good suggestion. I also would want to suggest that if I don't think you need to advertise this opportunity to the world, but there might be others. I know that Mr. Mortensen had some comments. There could be another person or two, or you would know them better than I would, AAG Buse and or Ben. But if there are others, I don't want to limit this to UEA, but if there are others that you think could help improve this rule, I would hope that you could contact those folks as well. And I took some notes too. Do any board members have questions? And I wondered if, I think one of the good suggestions, I don't want to belabor this too much, but I wondered if board members or committee members would benefit from just a minute description, if you could, Michelle, of UAPA and the Administrative Procedures Act and how this is similar and how it's different and why it might be good to have something in addition to what the law provides for. Would that be okay with committee members? I don't want to belabor this too much. Everybody okay with that? I'm not seeing any response.
Okay.
Okay. So why don't you just take a short overview?
Okay. The Administrative Procedures Act is put in place so that whenever a state action, thank you, Ben. He has put up the scope and applicability of the Administrative Procedures Act. It originally was put forward so that any state action that was taken, an individual who wanted to have that state action reviewed had a procedure to be able to do that and a timeline within which to do it. It's set forth so that the procedures are set out. Initially, the agency is required to designate whether a procedure is informal or formal. When it is formal, it's a lot more like a trial. And so the procedures are a lot more formal. The outcome of it is therefore appealable to a different level of court because it has been much more formal. The outcome of it is appealable to the Court of Appeals. And so the factual basis or the facts that have been determined in the hearing are carried over into the court. And it is not reheard all over again, the testimony and everything. Those facts are carried over. And so that's why Ms. Watson said it's less expensive to both parties because they don't do discovery over again. Those facts are carried over into the court. If it is an informal hearing, all of the rules of evidence and discovery don't apply. And so if a person wants to appeal that into court, that is a de novo review, which means it's done all over again. It's all brand new. And so discovery and all of the trial and the factual issues are all heard over again in trial. And so the informal appeal, although it is less expensive and generally less time consuming in the initial informal hearing, if it goes to court, it is more expensive because it's rehearing it over again. Another important issue for you to know is that the Administrative Procedures Act over the years has an extensive list of issues that it does not apply to, and that's what Ben is scrolling down through. This is the list of issues that it does not apply to. And so it is an extensive list of things that it does not apply to. And so we feel like in discussing between Ben and Chair Lear and myself, that we need it to be the rule to be broader than just what the Administrative Procedures Act applies to, that there are definitely some decisions that the board makes, that there are individuals affected by it that would have should have an opportunity to be able to appeal those decisions to the board. And so we tried to write the rule or the proposed rule so that it was broader than the Administrative Procedures Act, but to alleviate having to give definitions to every single word that was in the rule, to refer to definitions or procedures that were initially defined in the Administrative Procedures Act to say they could apply and be used in these areas that were initially excluded from the Administrative Procedures Act because they were procedures that provided due process to individuals. So I hope that was a Reader's Digest condensed version that you were thinking of.
That's great. And I see that that Member Davis has a question or comment.
That may have answered my question. I just wanted to clarify on one piece of the feedback from Tracy Watson. I felt like I thought she was saying that she was asking for an additional opportunity after a hearing before going to court, like some kind of an appeal opportunity prior to court. But perhaps what AAG Buse was saying is that it was specific to the informal process costing more going into court than the formal process. And I don't know how to solve that. So I think we should take AAG Buse's suggestion and allow this to go back and let some folks who do know the answers to all of these questions work on it for a while.
So is that a motion?
Yes. It's a long, wordy motion. I move that we table this topic for further work and bring it back next time.
Thank you. Any discussion to that motion by other board members or committee members? I'm not seeing any hands. Do you see any hands, Angie?
I do not. No hands raised.
So the motion is that we would table this discussion of R277-102 and allow AAG Buse and USBE staff to further consult and bring us back a new and not new, but an improved version of R277-102 next month or the next month, whatever the leadership decides. So all in favor of that, and any discussion to that final motion? All in favor, Member Haynes,
Aye.
Member Cummins,
Aye.
Member Thorpe,
Aye.
Member Davis,
I
and I also vote aye. Thank you very much. Thanks so much for your work on this, Michelle.
Thank you. Thank you so much, and thank you for the input that the public gave.
And thank you, Tracy, for your comments, and thank you for to Mr. Mortensen, who's not on the line. Moving to our next item on the agenda is 1.3 R277-312, employment of substitute teachers. This would be a repealed rule, which is the next item on the agenda, and then a new rule in its place. And we've had some concerns about this also, but let's just start with maybe an explanation of what's before us. So that would be, I think, either Ben Rasmussen or Malia Height from our
If I
license.
may, Chair.
Go ahead.
Thank you, Chair. So staff with R277-312, staff had a couple of objectives, and I'd like to go through those, and then we can open it up to questions and to comment. And Malia can add to that if she wishes. But the first thing we wanted to do with R277-312 was to create the last section in the rule, which is the section on the substitute certificate. This was an attempt to create a certificate that would have USBE monitor substitutes as an optional matter for school districts, so that we could monitor them for their background checks. This would help some districts in cases where they're not able to manage the wrapbacks for substitutes, like in circumstances where if they're working with temp agencies and that kind of thing. This was not meant to be a requirement that all substitutes have this certificate, but an optional procedure that would start in the next school year and would essentially be a tool that districts could use to have USBs help with that background check process. The other thing that we were attempting to do with this rule was to take the substitute rule, renumber it so that it's consistent with our other new licensing rules. We were not intending to change the status quo on the existing rules that the board had for substitute teachers. We haven't made a lot of changes there. However, we have received a lot of feedback from board members and outside parties that the status quo probably is problematic as far as what the licensing rules are for substitute teachers. And so I think today we're hoping to get some feedback from the committee as to what they'd like to see as far as the requirements for substitute teachers going forward, that maybe we can take that and look at whether we should redo this or just scrap it. And we'd also like your feedback and questions on this substitute certificate option, whether you think that's appropriate or whether you don't want us to go that route as well. But Dr. Hyde, do you have anything you want to add?
No, I think that you have summed that up sufficiently, Ben. I appreciate that. I'm just looking forward to the discussion and the feedback from the committee.
Board Member Lear, this is Angie. I did want to let you know that we also have one person, Tracy Watson, who would like to make comments on this rule, as well as, I should have said two people, Cindy Phillips also, and I'm not seeing her on, but she did email me. So we have two people, Tracy Watson and Cindy Phillips, who mentioned they would like to make comments on this rule.
Thank you. And I knew, I saw that request from Ms. Watson as well. So thank you. And I didn't limit the time before for the comments, but just in the committee's, to honor the committee's time. Can you limit your comments to 3 minutes, Tracy? Would that be okay? And we'll have that comment now.
Thank you, Carol. My name is Tracy Watson, Utah Education Association General Counsel. I just had a couple of comments. I'm working off of draft 1 in section 3. We talk about a first priority and a second priority and a third priority. And I've just sort of had to deal with that type of language with some of the districts as to what that means. Does that mean that in the first round of interviews, you'll only look at substitute teachers who have a license, or how is that first priority play out in its application? And then on line 58, there is a requirement that a regular teacher shall have lesson plans immediately available for use by substitute teachers. That sort of narrow directive is sometimes legally impossible. If the regular teacher is sick or out on FMLA, you can't make that requirement. It's my understanding. Your attorneys may have a different understanding, but those are basically my comments. Thank you.
Thank you very much. Board member or committee member thoughts, questions? Board member Vice Chair Cummins.
So I had a similar question that Tracy just mentioned with the whole priority list, and how is that easily applied in a setting where most of the time teachers are part of that process of selecting the substitutes through the district. And so anyways, I'm just curious, if we have that as a priority, how is that really applied and how is it applied? I just wonder if it's more cumbersome than it's worth even just saying that, it would be nice if districts could use licensed teachers as substitutes if available, which leads to my second question, which is the long-term substitute. In the law, where it states that long-term substitutes should be have an educator license. It says if available, except in our rule, we're saying they shall hold an educator license. And so is that putting LEAs in a predicament that we shouldn't be putting them in when the law isn't quite that strong?
Yeah.
And then my other question was just if we're going to go this route of the substitute certificate, I'd really like to know, is this a benefit to LEAs and how would this be a benefit? So I don't want to create something that doesn't need to be created unless it truly is a service to LEAs, and in what way would that be a benefit to them? So those are my questions.
Thank you. And I think those could be directed to probably to Dr. Height, but if you want to respond, or anyone else who has substantive information.
I'm happy to address some of those questions. Thank you so much for your comments. I agree that the priorities portion of the rule is, I think that we took it straight out of the old rule, and it certainly is, I think, a different era of education from when it was originally written. We're struggling to find, particularly this year, qualified teachers. And so having standards for substitutes that are hard to monitor, as has been mentioned with the prioritization, is challenging. As far as the substitute certificate goes, this is something that LEAs find to be a benefit for a couple of reasons. One is that it provides an avenue for USBE to monitor those substitutes through the UPAC monitoring and the FBI background wrap-back process, which is part of statute. The other is that it allows an opportunity for substitute teachers to receive some very basic classroom management and ethics and special education training prior to being in the classroom, which is a benefit not only for the substitutes and the LEAs, but also the students as they are supporting those needs. So those are kind of my first blush responses to those questions, and I'm happy to clarify anything from the board members.
Chair Lear, can I ask one follow-up?
Yes, please.
Sorry, just the question on the line 48, a long-term substitute teacher shall hold an educator license. That's just the question of making that stronger than the law. I'm just wondering why we're going that direction, why it's suggested we go that direction, and I'm not certain that we should.
If I may, Chair.
Yes, please.
So I think that I think you're right, Vice Chair Cummins. I think we may have overstated it a little bit in the rule. We had been talking about that, and that's probably my fault. But I think we could certainly, if we wanted to keep that in the rule when we going forward, I think we'd probably want to revisit that and either reference the statute or clarify that there is the caveat that that's not an absolute.
And Member Davis has questions or comments?
Thank you. I just want to read a little input from Board Member Belknap that she sent in. She said that she hasn't been able to kind of get a concrete response about who brought this new parts of the rule to the board, but she said, I honestly believe that if districts are concerned about their hired substitute companies, they can create their own district policies. We do not need to be prescriptive from the state board level. So I think that's something to consider. Do we want to take on monitoring of all of these substitute teachers while we are seemingly understaffed as it is with our responsibilities? And is there perhaps a middle ground? Do we shy of going with this big certification idea? Is there a middle ground where we could, somehow, is there already something in place where the substitute teachers have to be fingerprinted and they have to be background checked? And is there some system in place that flags an LEA if something comes up on that background check that's inappropriate for a person to be in a classroom? If there is, then maybe we don't need this. If there isn't, then maybe we need to look at a way to address that without going so far as a certificate that we have to monitor, or a license we have to monitor. And then the other question is on, or actually a positive that I see is on the training issue. So one of the benefits of having a state board of education is that we can provide some supports and resources so that local LEAs don't have to recreate the wheel all the time. I know that when I worked in a school district, I had 100 new substitute teachers every month, 1 hour to teach them how to teach. And it was easy. And I don't even know how the smaller LEAs are doing that. So I'm wondering, is there a way to cost effectively provide some online training that's meaty and helpful for substitute teachers across the state? But then, if the whole certificate is optional, allow the training to be optional for those LEAs that would like to use that as a resource. They could use that as a resource, but it's not one more thing that we have to implement a live or virtual training all the time. This could be just a resource we provide and they use it if they want to or not. And then they create their own teeth with their own hiring companies, just as they would with their classified employees. Those are my thoughts. My other thought is to echo what Brittany said. If we do leave in this part about a long-term substitute teacher holding an educator license, I think the language needs to be consistent with the law, and we need to add the caveat at the end. Also, I think the list, and I think these were here in the previous rule too, about the preferences of, teachers with bachelor's degrees and things like that. If we want to leave that in, I think it needs to be a recommendation and not a shall. And then perhaps our districts could counsel their substitute companies to electronically have these checkboxes, and substitute teachers check whether they have these things or not, and then the calls go out to them first. I do think that a rule like this kind of works when the economy is really bad and perhaps some more people are willing to substitute teach. I think in every other scenario, I hesitate on a rule like this because it seems that we are disconnected from the realities of the substitute teaching world right now in our schools, which Malia actually addressed in her comments, and I appreciate it. You know, we're begging for people right now to come and even just be in the classroom, and there are shortages everywhere. And so when you read this, it feels somehow that we are disconnected from understanding the realities in the field. Although ideally, this would be really great if we had a big pool of. So those are my concerns.
Thank you. Thank you very much, Member Davis. Did you need an answer to any of those, or were they mostly rhetorical thoughts or questions?
I guess I'm just wondering how many districts and schools are asking this, and I'm getting a text from another board member also asking the same question, so I'm going to throw that out on that person's behalf. How many districts and charters are asking for this, and is there a possibility for a middle ground or some of these great parts of this to be used as resources without going to the full bore rule that we have in front of us?
Thank you. So maybe to respond to that, Dr. Haidt or Ben, which one?
And Jennifer, sorry, Chair Lear, Jennifer Thronson also has her hand raised. I want to make sure you saw that.
Yeah, and I did see that. So whichever one of the three of you wants to first address Cindy's question, and then any follow-up you have, Dr. Thronson.
Let me just, if I may, just respond quickly to Chair Belknap's concern that a lot of the things in this certificate could be addressed by districts setting their own policy. One of the issues that has arisen that led us to look at the certificate is that there are some LEAs. There's a requirement that all the subs be enrolled in background checks, as with any employee or anybody that has unsupervised access to children. And there are some LEAs where they're facing circumstances where they don't have anybody that can actually have them in the background check and actually monitor them. So by having a certificate, we'd have them in Cactus or in USIMS down the road, and then we would be able to monitor them and basically notify the LEA if there was a hit, something they should be concerned about. I would defer to Jennifer and Malia to kind of talk about if they have specifics as to the numbers that have specifically asked for the certificate or that are facing that issue. But I don't think it's something that necessarily an LEA can just resolve by policy, as Board Member Belknap was asking about.
Jennifer, would you speak further?
Yes, ultimately, the reason this rule came to you at this time, I totally agree, it seems insensitive given the COVID-19 situation, is that we got an audit tip line, hotline call related to a long-term sub who had been arrested for drugs, and the LEA still had that person employed and teaching young children. And we're unaware, or at least to our knowledge, unaware of their arrest. And so we don't have currently in rule and practice, there's no great mechanism to alert an LEA that their teacher has been arrested because they're not a teacher, they're a substitute. Although this person had been serving long enough that they were on the school website as pictured as the teacher. This is just one scenario, but it's one scenario we would like to avoid moving forward with having some practice in place to caution or at least make an LEA aware so that when we get these tip lines, there has been awareness, there is communication that this arrest has occurred for a substitute they have in place to keep our kids safe. So just wanted to give a broader context. Malia and Ben can obviously answer the specificity of the rule. We would be happy to kind of take this feedback that we're getting today and come back with some revisions, of course. But I do want you to know there are problems that we are trying to face that are ones that we would like to avoid as much as we can through having a rule that is a little stronger and helping support our LEAs in knowing when they have people in their systems that might be putting kids at risk.
Thank you, Jennifer. But you're saying, just to follow up briefly, you're saying that's one LEA that expressed that concern or had that problem with one sub. Is that right?
This was just recently in a tip line, I think back in July. We got an audit tip, from the hotline. And so we looked into it and it was accurate. I've not been in the licensing space long enough to give you more of a history if this is a recurring piece. Malia might have some of that. Without having, Travis from the last 12 years, I'm not sure how frequent this is, but even for me, putting 30 kids at risk because we don't have a system in place to really monitor some of these substitutes that are in our system, especially in a long-term sub situation where they are there, impacting children over a longer period of time. Having something in place seems to make sense to me from a safety side of the house.
Thank you. Vice Chair Cummins, did you have another comment or question?
Yeah, just really quick. I'm just curious about our ability to, what would be the impact at USBE of monitoring, that many substitutes across the state as far as time and the ability to address it. How would we, anyways, just the bandwidth that we have at USBE to accomplish what's in this rule. And then second question is on line 45 to 47, it talks about that they can employ an individual who has a license revoked, et cetera. Is that somewhere else in rule, or is this the only place where we're making this statement in rule?
If I may.
Please, yes.
So with regards to that second question, that is also in the statute, I believe. There's a statute on substitute teachers that this rule has historically kind of expanded upon. So I think that is addressed. Certainly, if their license is suspended, if they have a license that's suspended by Utah, they are prohibited from working in the public schools or even volunteering in the public schools. So that is something that is kind of just trying to expand and reiterate upon statute. And then as far as staff capacity, I'd kind of defer to Malia. I think we had determined that we didn't think it would be too big of an imposition on staff and that we thought we could handle this amongst I think she indicated that the licensing staff could handle this without additional staffing, but I would defer to Malia specifically on that.
And Dr. Hyde, you had your hand raised on another before that. So do you want to respond to, or say whatever you needed to say and then respond maybe to Ben's point about staffing?
Sure, and thank you very much. The monitoring piece is actually going to be almost nominal when it comes to staffing and time and cost. For example, for this substitute certificate, this would be something that would be completely monitored within the USIM system. The training would live within that system and is something that a substitute candidate could complete on their own from home. And then once it was successfully completed, it would check the box that was done in USIMS. And then once the background and ethics review are completed, then the substitute certificate would be awarded automatically based on business rules. So it's not going to require any additional time from the licensing staff. The only additional time that it would require is if a substitute, like the one that Director Thronson had mentioned, had an arrest or some sort of issue come up, that it would require UPAC to investigate the claim or investigate the instance. And so
can I correct you there, Malia?
Yes, please.
If there's a hit on a substitute teacher, it wouldn't be for UPAC to investigate. All we would do is notify the employer that their substitute had a hit, and then it would be for them to evaluate what they want to do with their substitute. This wouldn't be having UPAC investigate substitutes. Just want to clarify that. Sorry.
Yeah. Thank you very much for that clarification, Ben.
But just
as far as the
sorry to interrupt, one kind of to add to that clarification, except UPAC would investigate if it were a licensed teacher who was subbing, right?
Yes, but we investigate all licensees, yes.
Okay, go ahead. Continue. If that's okay, Malia.
Yeah. Yes, thanks. The other, in reference to lines 45 through 47 in statute, it states that a substitute teacher may not work as a substitute if they are not, if the only reason that they can't be licensed is due to preparation, then they may serve as a substitute. However, if there is any kind of background check reason or a license has been revoked or suspended in the state of Utah or in any jurisdiction, then they know they may not serve as a substitute teacher. So I just wanted to clarify that that language is in statute as well. With regard to the number of LEAs who are requesting this is something that many of our charters, and when I say many, we're in the tens, 30 or 40 charter schools use USBE to do their background checks already for paraprofessionals and others. And this is something that the charters are already relying on USBE to provide this service. And so to be able to provide the service for a substitute is something that would be a service to especially our smaller LEAs.
Thank you. I have a comment from Cindy Phillips, who's a past director of a charter school, that she can no longer attend, but would like me to provide the substance of her comment. And then I have a short comment, and then I'd like to make a motion that I think reflects this consensus of what I'm hearing from committee members, if that's okay. So Ms. Phillips suggests that she feels this is cumbersome, unnecessary. There are some local concerns that they can handle this on their own, which is sort of contrary to what we just heard from Malia. So evaluate that as you will. This would not allow, according to Ms. Phillips, each LEA to take into consideration local factors such as hiring and experience and especially experienced substitutes, as opposed to one who may have jumped through the hoops but doesn't have the experience with the school. Feels like it's a huge. This is, I hope, not overstating Cindy's words, but this is a huge overreach in a year when we are scrambling for anyone who will sub. So those were the comments. It's summarized, not as well as Cindy would have made them, from Cindy Phillips. I noticed that before I move on with my second thought, committee member Davis had a comment.
Yeah, I wanted to piggyback. I don't know if any committee members have mentioned the line, and I apologize, I don't have the number in front of me, but that teachers shall leave lesson plans for substitute teachers. Is that a reference in code? Because that's just seems so understood. And there are going to be times when a teacher can't leave a lesson plan for a substitute teacher in an event of an emergency. And so I think I'm not sure about the strictness of that language. I have real questions about the whole certificate thing, but I would like to see if there is a way that we could look at if there's a way that we can somehow let people know if substitutes have been background checked, if something is flagged, why pay for a background check? So at that moment, you know that person's clear, but then you never get any additional information. So that is, I think, a valid concern. And the other piece is I'd love to see some real training happen as a resource, but not required to get a certificate or what have you, just that LEAs could use that for their training if they choose.
Thank you. Thank you for adding that, Member Davis. And just to add a couple of concerns of my own that have primarily been expressed, mostly been expressed, but and Dr. Height was great to talk with me earlier in the week about some of the same concerns I've had that have been expressed in this committee meeting. I have a real reluctance, though I hear you that some LEAs are maybe asking for help with this. I have a real reluctance to enter into the employment area of the board. By the board to do that, I think that these are employment issues for LEAs and they're not perfectly handled, but I think we are struggling to maintain our own statutory responsibilities as a board and board staff. My second concern is I do support the training idea if it's a resource, but I'm not, if all we have for training is the current ethics review, I said for years, and I can say this because I wrote it basically, it's had a few updates, but I think it's woefully inadequate and out of date, and I don't think requiring that of anyone is useful anymore, let alone that these subs that we're just hopeful that they're older than the students they're subbing for and that they have a pulse. So I have those concerns and some others I've already expressed, and I'm not convinced yet that the certificate is a good idea. If we can find a way, which I believe we can, with Ben working with BCI to allow the LEAs themselves to carry out the background check process, promote that with BCI. I think that would be a better way to go than to take this on as a responsibility of our office. So those are my ideas going forward. But, and I had one text, so let me just check that before I make the motion. Sorry about that. Which is not relevant. And there's one chat. Let me see that too. Hang on one second. And Ben makes a good suggestion, which will modify my motion that I'm going to make now, if that's okay. That the committee would like the staff to take this back, take our feedback, and come up with a pared down rule and consult with others, and perhaps that would be no rule at all. But we do currently have a rule in place that already provides for a lot of these things that we have spoken against. So the suggestion from Ben is that we repeal, which is the next item on the agenda, R277-5 or -312, I think. I can't remember the rule number. Yes.
508.
And then repeal that, and then ask the staff to continue work on what would become 508, I'm sorry, is the existing rule, and the staff would continue working on R277-312 and bring that back to us at a later date. So that was a long, drawn-out motion. But let me try it again, and without the repeal part. That the committee would like the staff to continue working on a proposed R277-508, and that would be my motion. Any further discussion to that motion? With great appreciation for their staff's attempts to respond to LEA concerns, and also trying to manage their own time. No, I don't see any comments, or I don't see any hands raised.
Carol, can I just clarify then what you're suggesting? So we're not necessarily repealing the rule, because there are pieces of this in statutes. We have to have some kind of rule, but you're just asking them to send it back and consider some of this feedback.
Yeah, I was thinking you're right. I was thinking we would repeal 508, but you're right. There are some requirements in statute that 508 includes, whether we've said them perfectly or not, such as the point that Member Cummins made about the overreach on the choosing licensed individuals for subs. But we'll leave that in place. I think that's the next item on the agenda. So let's just hold that thought. But
So, Chair Lear,
yeah,
this is Kathy. To clarify, this is to basically continue R277-312, not 508.
we would. What I'm suggesting, and I'm not sure which one is currently in place. I thought 508 was the current rule. Is that right, Ben?
So the current rule is R277-508. I think your motion on this rule would be for staff to bring 312 back at a future date, taking into a consideration committee feedback, And then you could make a separate motion to repeal R277-508, which wouldn't be required if you don't like the policy it espouses. So.
If we think that it needs to stay or go. That's exactly what I was saying. So the motion on R277 on this item would be that staff continue work on R277-312 and bring it back at a later date. So we'll take a vote on that unless there are further comments. I'm looking for hands and I don't see any. Member Cummins, what's your vote?
Aye.
Member Haynes?
Aye.
Member Davis?
Aye.
Member Thorpe?
Aye.
And I also vote aye. Thank you very much, and thanks for listening with open minds. It's been really, I feel like a good discussion, and I think there have been lots of additional participants. So the next motion on the agenda is, the next item on the agenda would be the repeal of R277-508, which is item 1.4. Does the committee have any comments to that? Ben, do you need to explain that further? I think we've kind of beat it up, but
just to clarify, I think Cindy had kind of hinted that this might be required by the statute. I don't think it is. So I think if the committee has concerns with the policy in 508, you could certainly. I think there are things that are in statute that you could certainly still repeal 508 if you don't like the existing policy.
You make a good point. I think some of the things we're concerned about in 508 as it exists are currently in statute. But are there any other comments by board members about what you'd like to do with 508? I am not seeing any hands.
Board Member Cummins' hand.
I apologize. Board Member Cummins. Vice Chair.
That's okay. So if we're okay, so I don't want to create any whiplash in the system where we repeal 508 before we have a new rule in place. But if there's nothing in the rule that's necessary, we can repeal it without the other rule being in place. I guess that was my question.
Yeah, and that would be a question. Yes, we could. So do you want to make that motion? Vice Chair?
Sure. I move that the committee repealed R277-508 on first reading and recommend the board repeal the rule on second and final reading.
So the motion is that the committee, let me first ask if there are any further comments to that, questions, discussion to that rule.
You've got a hand from Member Davis.
Member Davis, please.
Just to piggyback on that whiplash question, what is the benefit of repealing this now instead of repealing it in a month or two when we have a replacement rule? Is there a benefit, or are there pros and cons, or does it honestly not matter either way?
May I speak, Chair?
Yes.
It really doesn't matter either way. I think from the what Ben Rasmussen was proposing was because most of the comments today were stating that they didn't like R277-312, which is essentially what is in 508. And so if you were to repeal it, the provisions in statute in 53E-6-901 would stand on their own. And there is no requirement in there for the board to have a rule. But I also think it would be equally prudent, and you could just wait and bring it back next month if you'd like, when we bring back 312. So it's just up to committee preference.
So there are your pros and cons, our pros and cons. I think that's helpful. Thank you, Angie. Cindy, do you have anything further?
No, just it seems like typical practice that we repeal when we have a replacement. So this would seem like a departure to that, but I guess if there are no consequences either way, then I suppose it doesn't matter, other than the things that we talked about that could potentially be helpful that will be brought back, like a way to flag folks if there are background check problems and some training resources, but perhaps we don't need a rule for that. I don't know.
Thank you. Vice Chair Cummins, in light of those comments, do you still stand by your motion?
Yeah, because any of those things that we're talking about adding aren't actually in 508. And so they're repealing the rule as it stands wouldn't change the potential to move in that direction. So yeah.
Thank you. And I would also like to add in favor of Vice Chair Cummins' motion that I feel like a lot of the provisions in this are really old era kind of notions that are not happening anyway. And I personally feel uncomfortable having them in rule even for a month or 2 or 3, and feel like everything else that's necessary can be accomplished through statute or how LEAs and the SEA communicate. So I support the motion from Vice Chair Cummins. So with that, unless anybody else has additional thoughts, and I don't see any other hands, let's take a vote on the motion. Let me restate it. To repeal, that the committee would recommend to the board to repeal R277-508. And our motion would be on, I guess there don't have to be 2 readings on a repeal, but we would recommend to the board to also repeal R277-508. So if we can take a vote on that rather lengthy motion. Member Cummins.
Yes.
And Member Haynes.
Aye.
Member Thorpe.
Aye.
Member Davis.
Aye.
And I also vote aye. Thank you again very much. This doesn't seem like it should be so complicated, but all of your insight from staff members was very helpful. And thank you especially, Angie, for that brief pro and con discussion. We are moving to the next item on the agenda, which would be item 1.5. And this is an action item to discuss R277-462 school counseling program amendments. And our presenters are Kim Herrera, Jerry Sagers, and Jeff Van Holten. So I will turn it to any of the 3 of you who'd like to talk.
Jeff, are you unmuted now? Are you free to speak?
I am.
You okay? You're good now.
Speak to us.
Thank you. I'll be very brief. There's a little bit of feedback.
I just muted your phone number, so I don't know which one you want unmuted. I can mute whichever one you'd like.
Oh, is my microphone working on my?
Yeah, so I'll mute your phone and mute. Now I've muted your laptop, so use your phone for audio.
Great. Oh, much better. Thank you.
Yes.
Sorry, I've been trying to test out my tech here. So this one is very quick and easy. It is, well, I hope it is. Rule 462 is the school counseling program. This rule was in this committee. Kim will have to correct me on when exactly. It was, I believe, a couple months ago, maybe slightly even longer than that. But at the time, the committee requested that all of the incorporated documents that are incorporated by reference be made ADA compliant. And so what you are seeing before you is the incorporated documents are in your backup. They have been made ADA compliant, and therefore the edition has been updated to be the 2020 edition. So the only edit to the rule you're going to see is the incorporation by reference. We are required to state which edition and the year of the edition. So you'll see there on line 30 that we're changing second to third and 2016 to 2020. And we also are updating the web page link in the rule to the incorporated documents. That is it. I will pass it over to Kim if she wants to kind of highlight anything specific about the documents, and we'll turn it back to committee.
Thank you, Jeff. Kim, would you like to, Kim Herrera, also a specialist in this area, would you like to speak?
Open this great, and I'm just available for questions.
Oh, thank you. Board members, committee members, I'm not seeing any hands raised. Anybody have any questions for Jeff or Kim? Thank you both for your participation. I don't see any comments, any hands. Does a committee member like to make would you like to make a motion? Oops. Member Davis.
Yes, I move that we amend R277-462-3 line 1 to state this rule incorporates by reference the Utah College and Career School Counseling Program Model 2020.
Thank you.
Board Member Lear?
Yes.
I apologize. It looks like the motion is not in the background for some reason for this agenda item, but the motion would be that the committee approve R277-462 draft 1 on first reading and recommend the board approve R277-462 draft 1 on second and final reading.
Yes, Angie, do we need to include the requested action for the committee, which is underneath the background paragraph? That's the one that I just made. Does that not need to be included?
That's actually in draft 1. So when you approve draft 1, you do that.
Okay, I move that we do as Angie stated.
So the motion is for the committee to approve R277-462 as amended not as amended, but on first reading, and propose to the board to pass the rule on second reading. Any further discussion to that? Did I get that right enough, Angie?
Just second and final reading without objection.
Right, to second and final reading without objection. So any further discussion? I see no hands. So we'll vote on that. Member Thorpe.
Aye.
Member Cummins.
Aye.
Member Davis.
Aye.
And Member Haynes.
Aye.
And I also vote aye. So it's a unanimous vote. Thank you very much for your assistance with that. The next item on the agenda is item 1.6. This is an action item on R277-616, Education for Homeless and Emancipated Students. It's an amendment and a continuation. And to talk about this, we have Jeff Van Holten, Jeff Ojeda, Rebecca Donaldson, Dr. Leah Voorhees. Any of you who would like to start the conversation, I would leave that to you.
Great, Jeff Van Holten. I will do a quick intro and then pass it over to Jeff Ojeda, who has a brief presentation to kind of give you a summary of and a primer of this program, just to remind those who may be unfamiliar. But this rule is up for its 5-year continuation. This is the Education for Homeless and Emancipated Students rule. So we are asking that it be continued, and we are making one substantive change down on, Ben is grabbing that right there on line 65, 66, and 67. This is already a federal requirement. There's been some pushback from LEA saying, hey, it's not your rule, so why should I have to do it? So we are clarifying in the board rule that if a student is a McKinney-Vento student, they are they receive fee waiver pursuant to the way that fee waivers are given to all other students who qualify for a fee waiver. So while you're a McKinney-Vento student, you qualify for fee waiver pursuant to the fee waiver rule and the federal citation there, the federal code as well. But with that, I will pass it over to Jeff, but maybe Chair, if you have any questions, then he can give a little highlight on the program.
No, please, go ahead, Jeff. The other Jeff, second Jeff.
Jeff Squared.
Yes.
Thank you for the time. I really appreciate the opportunity to speak with you all and just give you some background information. I do have a presentation that looks like it's coming up now. If we can move over to the second slide there, just in terms of a background, the McKinney-Vento Homeless Assistance Act was signed into law in 1987. After that, it became a part of NCLB. And then after that, it became part of ESSA. And the important thing to recognize in regards to ESSA and McKinney-Vento is that the McKinney-Vento portion of the law was actually signed in October of 2015, which was about 6 months before the rest of ESSA was signed and completed by our leadership out in DC. So it's a part of the law that everyone was in agreement with and felt that there needed to be nothing to hold that back. And so it was continued as part of law well before ESSA finally got signed off on and checked for everybody to follow. So it provides formula grants for states. And the way that we do that is that we award 12 grants in the state of Utah. The awards go in a 3-year cycle, and we are currently in the 3rd year of that funding cycle for this year. Next slide, please. Thank you. So every SEA, State Educational Agency, has a responsibility that includes a person that can sufficiently carry out the duties of McKinney-Vento to ensure that McKinney-Vento students receive the full protections and services provided under the law. It also requires monitoring of LEAs, gathering and posting homeless data on our website at USBE, as well as collaborating with a broad spectrum of community services and partners, as well as with our LEAs to support students that are in this situation. In terms of local education agencies or LEAs, they have some specific requirements as well that we can see on the next slide. So their responsibility centers around identifying students, posting notice of rights to parents and youth in schools, providing professional development and support to school staff so that they can identify students as early and quickly as possible. It also it requires that we look into both preschool, Head Starts, and early intervention spaces for students that are in a homeless situation. And each one of those, Head Start in particular, has rules that apply to McKinney-Vento students. So one of those rules, as an example, is that at the start of the year, they have to leave at least 2 seats open in every classroom before those seats are given to students that are not McKinney-Vento. They are held open for McKinney-Vento kids in case any are identified and need to have that kind of service. So there is a great tie across a wide spectrum, all the way from pre-K even into higher ed, dealing with the McKinney-Vento issues that come up for our students. And it's also the responsibility of the LEA to connect families and youth in that situation to community services outside of their local LEA. And that's where that responsibility ends. So the funding that we receive does not go towards rent or paying bills of any sort or anything of that nature. All of our services are required to be academic services and supports for students to engage them in school and keep them engaged in school. Next slide, please. So in regards to who is eligible, the definition of a McKinney-Vento student is a student who lacks a fixed, regular, and adequate nighttime residence. And there are some specific caveats that go along with that, but that is the definition in which we base identification on. So that includes students that are sharing housing with others due to loss of housing because of economic hardship or similar reason. This is different than what you tend to hear in the news media when you hear about HUD and the Housing and Urban Development Department trying to count numbers of homeless people that they find in their area, that kind of thing. Their definition does not include families and kids that are doubling up. And again, the double up cannot be by choice. That is, if they're choosing to be with family or extended family, that's not a McKinney-Vento situation. The McKinney-Vento situation is when as a family or a student is doubled up with another family or friend, and they don't know how long they're going to be there. And they are there because of some kind of economic hardship or some kind of catastrophic event that put them in that situation. It also includes students that are living in motels, hotels, trailer parks, and camping grounds, or any space that isn't meant to be lived in. Can we go to the next slide? And we have a few more parts to that definition. So it also includes students that are living in emergency and transitional shelters. And we've done a lot of work, USBE has, in terms of working with our legislators to open up a broader definition for students who can qualify for emergency and transitional shelters, which has been great. It includes students that are living in cars and parks and abandoned buildings or substandard housing, bus or train stations or similar settings. There is some guidance that has been set aside by the U.S. Department of Ed, and I've noted the reference there for you to look at if you have some time. It's an interesting thing to read because it gives specifics on how to identify students that may be in tough situations, and they may not be listed in any of these. And then the last portion of the definition is for unaccompanied youth. And that definition is a child or youth who meets the McKinney-Vento definition, that is all of the above that we've mentioned, and is not physically in the custody of a parent or guardian. And our next slide, please. Yeah. So the purpose of the law is to remove barriers that derive from homelessness caused by a lack of fixed, regular, and adequate nighttime residence. It's there to remove academic barriers that may be caused by homelessness, barriers that hinder a student's full participation in school-sponsored activities. The goal is to have students participate fully in activity and not let anything hinder their academic progress, just like we would not expect any other students to have any hindrance in their academic careers. And to create stability in school for a student that's in a homeless situation, because oftentimes school becomes the only setting that is consistent for them, that is stable. And we know that's important because anybody who's going through homelessness is also dealing with a lot of trauma, and that comes in various forms as well. But the piece that we're kind of looking at here today, and the reason for, this conversation is that SEAs and LEAs must develop, review, and devise policies to remove barriers to the identification, enrollment, and retention of McKinney-Vento students. And that includes barriers due to outstanding fees or fines or absences. And there's the reference to the rule there specifically on the mentions of that. And then I wanted to also just give you kind of a picture of what McKinney-Vento looks like in our state currently. We just finished up, thanks to Aaron Bruff and his team, the data numbers for our last year in McKinney-Vento. And here is our 2019-2020 cohort graduation rate. So you see that our graduation rate for all students is 87% and our homeless is 69%. Which compared to other states is quite good. We have for quite some time been good examples in the McKinney-Vento area as a state. That's okay, we can go to the next slide, thanks. So it's important to recognize that as well. Our liaisons out in the field, they are doing an incredible job of trying to meet the needs of students that are in these situations. Here you have SAGE results for the 2017-2018 year. That's everyone compared to our McKinney-Vento students in gray. So everyone's in blue, McKinney-Vento in gray, or brownish, I guess. But you can see that our numbers are far less than we would like, but we continue working in that direction. In terms of what the makeup of our McKinney-Vento students is, you can see here that our top 15 LEAs with identification of McKinney-Vento students is listed, Jordan School District being our top district in finding and identifying students with 1,851 kids. I'll give you a moment to look at that. All right, if we can go to the next slide. Thanks. And this is our McKinney-Vento group of students by ethnicity and by services that we provide for them. So you can see that our largest population in McKinney-Vento is our Caucasian population of 5,333 kids. And also the largest subgroup in services is our low socioeconomic students, and that ranks about 10,034 of our kids. In total, for the 2019-2020 year, we have 11,576 kids who meet the definition of McKinney-Vento homelessness. And with that, like I said, just wanted to give you a snapshot and a brief overview of what the program is. But I'm happy to address any questions or field any questions or answer any concerns that you may have.
Thank you so much, Jeff. I have to take the chair's prerogative of saying this is sometimes a hard task for LEAs to serve, but I think they really try hard to follow federal law, and there is a little bit of federal compensation for students who are served under McKinney-Vento. So I hope that LEAs know that, and it sounds like you're doing a good job of getting that word out. And a brief shout out to Salt Lake District, because I know that that's where I live and that's where I represent, but I also know that they try very hard. There's a area in Salt Lake District that is made up of a lot of homeless youth, and they try very hard. The district tries very hard to serve those students and be flexible with them. And I think that's just a great example. And I'm very proud to represent Salt Lake and live there for that reason, among others. We have some other comments, questions. They are from, no, it's in the chat. Hang on a second. Cindy, who says, thanks for the presentation, Jeff. Any other questions or comments from board members? If not, certainly a motion is timely.
Board Member Thorpe has her hand raised.
Thank you. Board Member Thorpe.
Just a comment, and then I will make the motion, if that's okay. I just wanted to say I worked with Jeff, and I appreciate his work for our homeless students, and I believe that this is a really good rule to reinforce some of the things that they need to support what's happening at Good Change. So I would like to make a motion that the committee continue and approve R277-616 draft 1 on first reading and forward to the board for continuation on second and final reading.
Any discussion to that motion? Further? I see none. So let me repeat the motion that the committee continue and approve R277-66 draft 1 on first reading and forward to the board for continuation on second and final reading. And that's the motion. I see no further discussion. Let's vote. Member Haynes.
Aye.
Vice Chair Cummins.
Aye.
Member Thorpe.
Aye.
And member, who did I miss? Davis?
Aye.
And the chair votes aye. And Jeff, we did say, Jeff is reminding us to make it continued and amended. The motion was the committee continue and approve R27616. So I think we did our duty. With that, the vote is unanimous. And thank you, Jeff. That was Jeff Ojeda. All of you. That was really helpful background. And I hope that background will be available for the board, if not the presentation, when the board reads this rule next month, because I think there's not a common understanding of sometimes the McKinney-Vento program. Thank you.
You're very welcome, and I'm happy to help in any way I can. If you need for me to do anything else, please let me know.
Thank you. We have one more item on our agenda. That would be item 1.7, which is also an action item. R277-494, Charter Online Home and Private School Student Participation in Extracurricular or Co-curricular School Activities. And this would be an amendment and a continuation. And Angie, you are designated.
Yes, thank you, Chair Lear. And I was going to turn on my video, but it's not allowing me to. So maybe the computer knows something I don't know. But anyway, this rule, R277-494, is up for continuation. It's through its 5 years, and it's up for its 5-year review. Just as a point of information, and Board Member Davis has her hand up. Can you hear me okay?
I can hear you. Let's see what.
Yes, I can. I just have it up for when you're finished.
Oh, gotcha. Thank you.
Thank you.
Great. There are 3 sections of code that this rule relates to: 53G6703, 53G6704, and 53G6705. What this rule does is it supplements those sections of code that allow a student who's a home, a school, private school, charter school, or online school student to participate in extracurricular or co-curricular activity at their boundary school, or what would be their boundary school in their district of residence, if their school does not provide that activity. As you go down below, there were some requirements in code that we are required to establish rules around. That's what this rule does. The only changes in this draft are to change the 2 definitions that Ben is showing right now on the screen, starting on lines 31 through 39, and that's just to change those 2 definitions. They are now included in code. When we had this rule 5 years ago, those 2 terms were not defined in code, and now they are. There's also a technical change below where we had the wrong citation for the school fees rule. And other than that, the staff recommends that this rule be continued and recommend that those technical changes be made. And I'm open and ready to help answer questions if board members have any questions at this time.
And let me just mention, before I go to Cindy Davis, mention, Angie, it looks like under the authorization of the rule, 703 is in the body of the rule, but not in that top authorization part. Is there a reason, or is that just a technical oversight?
No, you're right. No, there is a reason. And the reason is both 704 and 705 explicitly require us to establish rules, but not 703.
Okay.
We could include 703, but it doesn't explicitly give us any authority to do anything, whereas 704 and 705 actually require the board to establish rules.
That's helpful. Thank you. Member Davis? Cindy, do you want to ask?
Yes, thank you. I'd like to make a motion, and I'll ask Deputy Superintendent Stallings to help me if it's too convoluted.
Okay. Well, I mean, is it discrete? I mean, should you make this motion, or do you want to hear more discussion?
Let me make the motion, and then I can speak to it, and others can speak to it as well.
Okay, let's do that.
Be all right, Chair?
Yes, please, go ahead.
Okay. I recommend that the committee continue and approve R277-494 Draft 1 on first reading and forward to the board for continuation and approval on second and final reading, and change the participation fee from $75 to $100, and bring back the rule at a later date to potentially include participation in charter extracurricular activities. And I'd like to speak to that motion.
Please do.
Okay, so as we were kind of preparing for this meeting, Deputy Superintendent Stallings, I think these were a couple of questions that you took to an advisory group made up, if I understand correctly, of district superintendents and charter directors. And if I understood the feedback that you got from them correctly, you know, that $75 was sort of a shot in the dark. It's when we created the rule in the first place, it's a pretty nominal fee to participate. Even $100 is, but I think the feedback was we don't want to go crazy on that, especially in a time of very limited resources right now, but at least make a somewhat of an increase. And then the other issue was that we have home and online and neighborhood district school or charter school folks that can participate in extracurriculars in a neighborhood district school. But we actually have some cases, and correct me if I'm wrong, Angie, that where we have some of the folks in these types of schools that are already participating in charter extracurriculars within the district boundary or the neighborhood boundary. But there was some thought that that piece would need to be brought back at a later date to make that official, because we needed to check with Utah High School Activity Association and do a little bit more digging in that arena. So that's my understanding of where we're at on this issue. And I would invite Deputy Superintendent Stallings to just help me to know if that understanding was accurate based on the information she got from the advisory folks she visited with.
Angie, please.
Great, thanks. So yeah, I'd be happy to clarify the feedback. So as Board Member Davis stated, each month I meet with a group of people, mostly it's superintendents, charter school representatives, district representatives. And in that meeting, number one, they stated that they didn't see actually a need to raise the fee amount at all, but if there was any kind of a raising of the fee, that it be nominal. So that was their first recommendation. The second recommendation, it was more of an acknowledgement that currently there are school districts that have agreements with charter schools, and there are school district students that are currently participating in activities at charter schools. One example that was given was Highland High School students participate in the Salt Lake Arts. I'm sorry, I'm trying to remember the name of the School for the Performing Arts. It's a charter school in Salt Lake. And so mostly what the committee members wanted you to know is that we have school district students participating in charter school activities through agreement. And so in that sense, it's kind of right now on a voluntary basis. So then the question was, and I think this is what you're asking. So I don't think there are no rule changes that need to be made to support the facilitation of that. That can happen right now without any rules or laws being changed. I think the question that I then proposed to the committee is whether we would want school district students to have the same right, meaning where a charter school wouldn't be able to deny it. So remember, in this case, school districts don't have the authority to say yes or no to these students as long as they meet the criteria. They have to allow this to happen. It's up to the student as long as they their school doesn't have the activity and it's their boundary school and they meet the other qualifications like the citizenship, and they have to try out, of course. So currently, if you don't do anything with the law or the rule, school districts and charter schools on their own can facilitate this. But if you want charter schools to be required to allow school district students to participate in activities in their charter schools if, again, we'd have similar criteria, like the school doesn't offer the activity, and you might either do some sort of a mile marker, or what the committee proposed was allowing students within a district to participate in activities at charter schools that are located physically within the boundary of that school district. That was what the committee proposed. So there's a lot of things to talk about and flush out. The committee also recommended that we work with Utah High School Activities Association if we were going to go down that route. So I just wanted to state that there's no changes to rule that have to be made. It's only if we wanted to go down that road of saying students have a right to participate in a charter school's activity, and that could be something like a jazz band, or it could be lacrosse or ultimate frisbee, where some charter schools might have that as a sport or might have that as an activity, but the student's district school does not. So hopefully that helps give a little bit more of the flavor of the feedback that we received.
Thank you, Angie. Let me ask a clarifying question about the motion, and then I'll go to Vice Chair Cummins. Cindy, on your motion, did you propose that the 75 be raised to 100 immediately, or that was something that would come back in a month or two or three?
Well, we had just discussed earlier on that the 75 was sort of a guess in the beginning, and it's pretty nominal. So I think it should be changed immediately, and I think it has to go both ways. I mean, if our district students or our home and online students are going to participate in our charter extracurriculars, then they should be paying that fee for that extracurricular participation as well.
Sure. Thank you. Thank you for the clarification. Let me just clarify that the $100, again, if it goes either way or both ways, qualifies the student for any and all extracurricular activities that the student wants to participate in. It's not per activity. So it is very nominal given the possibilities in some.
Chair Lear, can I also just clarify that? First of all, the $100 is paid by the school, the charter school or online school, to the district school. So I think what you're saying is we would do that the other way, where the district school would have to pay the charter school the $100. But that is in addition to any activity-specific fees. So remember that if the students participate in volleyball and there's a $300 volleyball fee, that the student pays the $300, or if there's a fee waiver, the charter school or online school pays the $300 to the district on behalf of that student.
Right.
The other thing I wanted to mention is it might be helpful to split the motion into two, because the portion about asking staff to work on the rule and bring it back doesn't actually need to be approved by the board. It's a committee motion to direct staff to do something and bring it back. So you may want to split the motion on approving draft one with the amendment, and then do a second motion directing staff to reach out to stakeholders on feedback related to allowing school district students to participate in charter school activities, and just do that separately as a motion to direct staff to do that. That would be my recommendation.
That makes sense. Go ahead, Cindy. And then I need to.
So moved.
Okay, there will be two motions that you're proposing, well, sort of motions at the same time. There was another clarification that I wanted to ask about in Angie's comment that I can't remember right now. It'll come back to me. Vice Chair Cummins.
Yeah, I'd like to move that we amend the motion to remove the increase in the fee. So remove the change from $75 to $100. This is an access fee only, and we have no evidence that the fee needs to be raised, or I think any government entity, as they raise a fee in any place, needs to have evidence that it's a necessary raise of a fee, that there's a need for it or it accomplishes something. This is an access fee. The student pays the participation fee. And so the question is what is this access fee used for, and is 75 too high? And so I would like to move that we don't make that amendment in this particular rule. And as the feedback comes back, what is the right amount? Is it less than that? Is it more than that? But not just raising it just because it's a nominal fee for no reason at all. So I would move that we remove that amendment.
So I guess what you're saying is you don't support the first part of, if we divide this motion, you would not support the raising of the fee, is what you're saying.
So the motion was to continue the rule. I'm in favor of continuing the rule. I'd like to remove the proposed change to the rule in the motion that was made.
Okay, now I hear what you're saying. So, but that would not mean we would split the motion, but I guess it has the same effect. I'm trying to figure that out. What do you?
So Board Member Davis made one motion with to continue and so I would like to, as my amendment, I would like to remove the and, I guess is what I'm saying. And so as a committee, we can vote whether or not we want to remove that part that she added, and then we would, if it passes, if my amendment passes, we would just continue the rule. If my amendment doesn't pass, we would continue the rule with the amendment.
With the direction, but you're also saying you do like the idea that with the direction to the board, to the staff, to continue working on this and bring it back to us in a couple of months with perhaps the opportunity, the fairness opportunity for students to go both ways. Is that
correct? Sorry, I wasn't sure you were taking a vote on the division or not, or if that was just assumed. I apologize.
And I'm not sure either. We'll think about that in a sec. But let's hear from Member Davis, who made the motion.
Yeah, I guess I have a question. Maybe Angie can help us with this. You know, I think the whole rule is just sort of ridiculous anyway. I mean, if you choose a district school, you should choose that with whatever it offers. If you choose a charter, you should choose that with whatever it offers. And but you know, since it is in place, why was the fee established in the first place? Was that in code? And I'm getting this question from another board member also via text. So I'm also, I guess, asking for both of us. And realistically, you know, it often costs more than what we're even asking in school fees to run these extracurricular programs. It's not cheap. And so then to force a school to take on additional students that don't go to that school, you know, what are the costs? What are the impacts? It's really hard to get that data. I inquired about the data, and Angie, I believe, asked at this advisory board meeting too, and they said it could be kind of extensive to try to figure out what the impact is, but not knowing it, I guess I'd like some background of where the fee came from in the first place.
Can I speak to that for just a minute, and then I'll let Angie add to what my institutional memory is. That fee was established initially per the legislative direction because, and it predates the local replacement discussion and payment back and forth from school districts to charter schools. So at the time that the school district was had all the money essentially that came in from tax revenue, and none of that went to school districts or to charter schools. Then the local replacement idea developed, and there started to be money going from the districts who collected all the tax revenue, and it's not this literal, but districts collecting all the tax revenue to the appropriate charter schools that are enrolled from those charter school students who enrolled from those districts. Hope that makes some sense. And it was initially a somewhat of a shot in the dark. When the board first set that fee, there was a laundry list of fees. So where that probably more accurately reflects the actual cost for these activities. For instance, football was $400, a payment from the charter school to the traditional school of $400. In addition, that the student would still pay the fees, because as Cindy points out, the student fees don't begin to cover the costs of these programs. Usually, that's a generalization, but football costs way more, and there is some revenue too, but it costs way more than what students pay in fees. So the schools, the traditional schools do pay a lot of money to establish a program, a football program, a marching band program, a soccer program. And that the purpose of the fee was to compensate the traditional school for just in a very little way for what the school puts in out of its funds differently than what the charter school, where the charter school doesn't have to build the football field. It doesn't have to have a soccer field. It doesn't have to establish a complete marching band program, including all the employees who go along with that. So that was and I actually did participate very avidly and with passion in the fairness of that, which has somewhat now been moderated by local replacement money going back and forth. But Angie is trying also to add some information.
Yes, thank you. Sorry. So to answer the first question, yes, both 53G-6-704 and 705 require the board to establish a fee for each charter school or online student who participates in an extracurricular, and we've added co-curricular activity at a school district school. They are required to pay a share of the school district's costs. So it is meant to, as Board Member Lear stated, offset some of that portion that is subsidized by the school district. So hopefully that answers the first question that board members had. We are required by code to establish this fee. When and some of you were around 4 or 5 years ago when we reviewed and rewrote this rule significantly. And at that time, in 2016, I believe it was, we also did a survey at the time. This $75 amount has been in place since the existence of this requirement. So I would say 2005 or whatever.
15, at least 15
yeah.
years.
And so the fee amount has never changed. And at the time, 4 or 5 years ago, when I asked districts if they thought the fee should be increased, they did not. They said, no, just keep it at $75, because for them, it's very difficult, depending on the sport or the activity, the amount that is subsidized by the district changes. And so the superintendents felt like, the $75 is a fair amount. It helps engage the charter school or the online school in knowing that their students participating. But this time, the whole committee felt like they didn't want to increase the fee at this time, because they felt like there's a statewide effort in general to reduce fees. And so they were fine leaving it at 75. So hopefully that's the background on the 75. It is required by statute, and it's been the same ever since the statute passed. I did want to give you some information that was shared again at this committee, and it came from both Lexi Cunningham and Royce Van Tassel, and I apologize. I hope they don't mind that I'm sharing this information. But both of them mentioned that generally those who use or rely on this rule most are online, homeschool, and private school students. And actually, online school and homeschool students are the most prolific users of it. So in general, most charter school students that are going to an in-person type of school, they make that decision to not be on the swim team or the football team when they go to the charter school. They often attend the charter school with the intent to stay and participate in the activities there. That was the information from Royce Van Tassel. So he said from the charter school side, you're usually seeing students who are enrolled in online programs who want to participate in the district programs. And then Lexi Cunningham stated that from her experience back when she was at Salt Lake City School District, most of the students who participated were homeschool students or online students. They didn't have really any traditional charter schools students who wanted to participate. And I don't know if that's helpful information or not, but this goes to, when I asked the group if we could do a survey to get more data on this, this data would all be collected at the school level. So it's not something that a district would have at their district office, but is managed at the specific high school. And they felt like it would be a lot of work to ask high school principals right now to gather that data. But the information that from Royce and Lexi at least gives you hopefully some a sense of that this isn't maybe as prolific or as widely used by general charter school students. It's more focused on it's more mostly used by our online charter school students.
Thank you. I think we've overwhelmed you with background. So let me see if anybody else is raising their hand. Sorry. I don't see any more hands raised. Just for convenience, is it okay? Oh, Cindy, you do have your hand raised. Go ahead. Member Davis?
Yeah, I really don't care who's using it, whether it's a charter, online, homeschool, whatever. I just think to force, one school to accept students and that they have to subsidize and those schools aren't attending, that there should be some compensation. And I'm willing to accept that as a friendly amendment and just withdraw the request to increase. I think I also may have misunderstood Angie. So I think that the folks from the advisory committee are saying we don't necessarily need an increase at this time, especially with the, the problematic resources that are out there during the pandemic and the whole discussion on school fees. But I would certainly caution this committee to say, if the $75 fee was kind of a shot in the dark, we need some information and some data. What is the impact here? And in 15 years, certainly expenses have gone up. I mean, you've got a close to 2% just inflation rate. So I think at a later date, it would be appropriate when we're not in a pandemic, maybe to have this conversation again. I mean, I'll withdraw it for today. But I think that we are sort of operating blindly by just taking people's opinions and not really having data and impact to make wise data-driven decisions. Sounds like it would be difficult to get that, but I'm just throwing all of this out on the table. So with that, I withdraw that portion of the increase and will accept Brittany's amendment as a friendly amendment, or I'll just withdraw it so maybe you don't need the amendment anymore. And I'll go back to the original motion without the increase, and then the second motion to bring it back, looking at the sort of the two-way street.
Eventually, in the next month or two. Is that what you were?
Correct.
Or sometime at the leadership's discretion.
Yes.
Okay. Mike Haynes, let me weigh in, and then I have another thought. Go ahead.
Thank you, Chair. I was just curious what the data is on that and where these students are coming from. Are they charter? Are they private? Are they homeschool? As we look into this, will we see the numbers of where we are today or what the past has looked like and what we expect the future to look like?
Yeah, and I think that's what was buried in Angie's explanation and maybe a little bit in mine, that doing that kind of survey would be very labor intensive because it wouldn't be an LEA survey as much as it would be a school to school survey, because many of the students who participate, whether there are hundreds of them or whether there as a handful, every school negotiates or works with the student. And
that
so,
data does roll up to the state.
And the other thing about it's a similar problem with the amount of money. An additional charter school student playing football at Hunter High School probably doesn't add a lot of cost to that for that traditional school. a charter school student playing at Ogden High School football would probably add a greater amount of concern or financial burden to the Ogden High football team. So that's, I think, why it's also hard to evaluate. And marching band the same as football? Is debate the same as football? Is basketball the same as soccer? I think that's the challenge with the survey. And unless I could be convinced that we could get meaningful data, this is to Cindy also, to board member Davis, unless we could get meaningful data that is comparable from school to school, I'm reluctant to ask for more survey information. So I'm uncertain about that. But I just wanted to add that piece that's my concern. But I agree with you, Cindy, 100%. This is a very nominal amount of money, and I sort of hate to babysit school districts who say we don't need sort of trouble that that the burden should be shared. If we're going to have football fields and marching band programs, I think the burden should be shared by all those who participate. And again, my opinion. But right now we have a motion that is, if I can repeat it accurately, the committee moves, or Member Davis moves that the committee approve R277-494 as amended and ask for it to be continued, and then also ask that the board staff continue to work with LEAs and others to make changes to this rule in the next few months and bring it back to the committee as directed by board leadership. Was that accurate?
Yes, except for we had asked that those two motions be separate so that we'd have one motion for the board, and because the second part of the motion the board does not need to approve.
Okay, so just end it at the...
Yeah, Ben, could you just show the memo on the screen? Because you could just restate the recommended action right there as the first motion.
So it's really nothing. I've got it right here too.
And it's not amended, is that correct?
It is amended. It's continued and amended. So it's draft 1. So you'd say the committee continue to approve R277-494 draft 1.
Hold up. Yeah. I've got it on first reading, forward to the board for continuation. And then what you're saying, Angie, is it's an understanding from the committee to the staff that you'll continue to work on this.
Yes. In fact, I agree with you. You don't even need to make a motion. Okay. We've got that. We'll start working on it. It'll take a couple of months. It's a bigger and larger issue, I think, than it seems. Well, I think we all get the idea now, just with the discussion we've had here, that there's going to be lots of different interpretations. And I think school districts may want to weigh in on how they'll facilitate this and pay the money to the charter schools. The High School Activities Association will have issues. So I wouldn't anticipate we'll have anything ready by October, potentially November, and more likely, I would say December.
That'd be great. I don't think anybody's putting a timeline.
So yeah, I think this motion that's on the screen right now would be sufficient for now.
So if you're okay, Cindy, and without objection, the motion is the committee continue and approve R277-494 draft 1 on first reading and forward to the board for continuation and approval on second and final reading. Is that all right, Member Davis?
Yes, thank you. And thank you to all of you for the background and the conversation.
Thank you. So with that motion now, we'll take a vote. Member Haynes?
Aye.
Member Vice Chair Cummins?
Aye.
Member Thorpe?
Aye.
Member Davis?
Aye.
And I vote aye also. So it was a unanimous vote. Thank you very much. And yes, thank you for all the background and the work, Angie, of taking that discussion to the superintendents. I would just request that when you discuss this again with superintendents, which may be in 3 or 4 months, this come back, I would like to hear their discussion so I could hear if they have a a clear understanding of the history and the background and the amounts of how the amount was determined in the first place.
Absolutely. We could invite you. Yeah, and you could attend.
And you
That's
offered,
great.
I hope I'm not being a Budinsky because you offered before on a different issue. So
Absolutely. You're always welcome.
if that's okay. All right. So I don't think the committee has further business, does it? If any members have any comments, I'm open for those. And go ahead.
Thank you, Chair.
Thank you.
You
Thank you
and
very
all the
much.
staff.
Thanks, Mike. And
We've
thank
got a
you,
great
Rebecca.
staff.
Yes, we do have.
Yes.
We had helpful
Amazing.
information from staff. Thank you. Have a good rest of your day.
Thank you.
Thank you.
Enjoy the holiday weekend.
Thank you.
Oh, yeah. Happy birthday, John Lear, right?
Oh, yes. 70th. Woohoo.
Yeah. Thank you. Bye.
See ya.
Jerry, are you okay with me ending the session? I think if I go out, it'll end the session. Is that okay? I'm going to take that as a yes and go ahead and end the session for everyone. Have a great day.